My name is Jonathan Culbertson, and I am the Compliance Manager at InCheck. Today, I will be bringing you the August 2022 edition of InCheck's Compliance Update Vlog. As always, I will be highlighting some recent legal updates that affect background screening and the hiring process. Okay, let's get started. As previously reported, the Department of Homeland Security, or DHS, extended the flexibility that allows employers to virtually inspect identity and employment eligibility documentation for purposes of completing the Form I-9. For today's update, I would like to highlight that on August 18th, 2022, DHS published a proposed rule entitled Optional Alternatives to the Physical Document Examination Associated with Employment Eligibility Verification. Although the publication does not make the aforementioned flexibility permanent, what it does do is propose a rule that would formalize the authority of the Secretary of Homeland Security to extend flexibilities and provide alternative options for document examination procedures with respect to some or all employers, regardless of whether their employees physically report to work at a company location. Interested parties may submit electronic comments regarding the proposed rule through the federal e-rulemaking portal by October 17th, 2022. Next, I want to discuss Colorado's Senate Bill 22-099, which went into effect this past month. To start, the bill amended the Colorado Consumer Credit Reporting Act in two key ways. First, the bill added that consumer reporting agencies, CRAs, such as InCheck, are prohibited from reporting sealed records, expunged records, and records that did not result in a conviction. Second, the bill removed the $75,000 salary exception from the Colorado Consumer Credit Reporting Act. So traditionally, the act provided that its reporting restrictions on CRAs were not applicable if the report was used in connection with the employment of an individual that was reasonably expected to earn $75,000 or more annually. However, now, consumer reporting agencies can no longer escape the Act's reporting restrictions for report used in connection with employment of such an individual. The bill did not stop there. The bill also provided that beginning July 2024, certain convictions will be automatically sealed. Such convictions that may be sealed include those in which the judgment is for a civil infraction and 4 years have passed since the final disposition, or the conviction is for a petty offense or misdemeanor and at least 7 years have passed since the final disposition. And third, the conviction is for an eligible felony and at least 10 years have passed since the final disposition. Last, let's conclude today's video by briefly discussing some legal updates regarding marijuana. Minnesota recently passed House File 4065, which states that edible cannabinoid products may be sold for human consumption if the product does not contain more than 5 milligrams of any THC in a single serving, or more than a total of 50 milligrams of any THC per package. The law does not contain any employment protections. Now let's move over to Nevada. Nevada revised statute 613.333. That statute creates a private right of action for employees who are discharged from employment for engaging in the lawful use of any product outside the premises of the employer during the employee's non-working hours. Recently, though, in Ceballos versus NP Palace, the Nevada Supreme Court held that recreational marijuana use does not qualify for protection under that particular statute. And last, I just wanted to put something on your radar. California is considering a law that would provide employment protections for off-the-job cannabis use. Specifically, California's Assembly Bill 2188 would amend the California Fair Employment and Housing Act to make it unlawful for an employer to discriminate against a person in hiring or termination if the discrimination is based upon the person's use of cannabis off the job and away from the workplace. Now, this bill would still need to be passed by the California Senate and signed by the governor to take effect, but I wanted it to be on your radar. Thank you for joining me for the August 2022 compliance updates. I hope to see you again next time for some more compliance updates. Thank you. Bye.